Hello students, welcome to EPG Pathshala. I am Prakash Sharma from Faculty of Law, University of Delhi. Today we are going to discuss about module Rights of Accused Women under paper Women and Law in Women Studies. We shall be discussing about objectives. The first objective is raising awareness regarding rights of accused women. The second one is to ensure full understanding of the prevailing rights of accused, any needs for its improvement, particularly concerning women. Third one is realizing the aims and objective of human rights vis-a-vis special attention on rights of vulnerable section of the society. The scheme of presentation is we shall be discussing first about introduction, thereafterwards provisions of Indian Constitution and Criminal Procedure Code. Within these provisions, we shall be highlighting specifically on legal aid, right to speedy trial, some other provisions of right of accused. Thereafterwards, we shall be discussing finally on conclusion and suggestions. Now, the three important segments of any criminal justice system, that is the police, the judiciary, the prison, works through certain institutions. These institutions are attached with correctional methods, which are ought to be functioning in a harmonious and tenacious mode. The two central principles of criminal jurisprudence are that the prosecution must prove its charge against the accused beyond reasonable doubt, and the onus to prove the guilt of an accused to the hilt is stationary on the prosecution. Now, Indian Constitution itself provides some basic rights, which are also termed as safeguards, to an accused person that needs to be followed by authorities during the process of criminal administration of justice. The Criminal Procedure Code deals with procedural aspect of arrest of an accused person and provides various rights to an accused person. There are some provisions which expressly and directly create important rights in favor of an accused or arrested person. Certain international provisions, these are Article 11, Para 2 of the UDHR, which is Universal Declaration of Human Rights, 1948, and Article 15 of International Covenant on Civil and Political Rights, which is ICCPR, 1966. Both of these two conventions and declarations provide that there shall not be any ex post facto laws applicable to an accused person. Further, Article 5 of UDHR 1948 and Article 7 of ICCPR 1966 prohibits use of medical or scientific experimentation without free consent of the accused. Now we are going to discuss provisions under Indian Constitution. First one is protection against ex post facto law. Clause 1 of Article 20 of the Indian Constitution says that no person shall be convicted of any offence except for violation of law in force at the time of commission of the act charged as an offence, nor be subjected to any penalty greater than that which might have been inflicted under the law in force at the time of commission of an offence. In Kedarnath versus State of West Bengal, 1953, the Supreme Court held that the enhanced punishment could not be applicable to the act committed by accused in 1947, and hence it set aside the additional fine imposed by the amended act. Another is prohibition against self-incrimination. Clause 3 of Article 20 provides that no person accused of any offence shall be compelled to be a witness against himself, the cardinal principle of criminal law which presumes an accused innocent till the contrary is proved. In Nandani Satpathy versus P.L. Dani, 1978 case, the Supreme Court has considerably widened the scope of Clause 3 of Article 20 and held that the prohibited scope of Article 20, Clause 3 goes back to the stage of police interrogation, not commencing in court only. It extends to and protects the accused in regard to other offence pending or imminent which may deter him from voluntary disclosure. Now, Article 5 of Universal Declaration on Human Rights and Article 7 of International Covenant on Civil and Political Rights, as mentioned earlier, prohibits use of medical or scientific experimentation without free consent of the accused. This has been categorically mentioned in Srimati Selvi versus State of Karnataka in 2010. The Apex Court held that the use of medical or scientific experimentation without the free consent of an accused is violative of constitutional provisions. It is also a reasonable restrictions on personal liberty as understood in the context of Article 21 of the Constitution. The right to be informed of the grounds of arrest is also covered under Article 21 Clause 1. Article 21 Clause 1 of the Constitution provides protection of arrest and detention. Section 50 Clause 1 of the Code of Criminal Procedure Code 1973 also creates a stricter duty on the part of police officer making the arrest and would mean immediately. The right to be informed of grounds of arrest is a precious right of the arrested person. This right is recognized by Section 50, 55, 75 in cases where the arrest is made in execution of a warrant of arrest or where the arrest is made by a police officer without warrant. If the arrest is made by a magistrate without a warrant under Section 44, the case is covered neither by any of the Section 50, 55 and 75 nor by any other provision of the Code of 1973. This requires the magistrate to communicate the ground of arrest to the arrested person. Right to be defended by a lawyer. It is one of the fundamental rights enshrined in our Constitution, where under Article 22 Clause 1 of the Constitution, no person who is arrested shall be denied the right to consult and to be defended by a legal practitioner of his choice. The right of accused to have a counsel of his choice is a fundamental and essential to fair trial. The Criminal Procedure Code has specifically recognized the right of a person against whom proceedings are instituted to be defended by a counsel. According to Section 303 of Criminal Procedure Code 1973, any person accused of an offence before a criminal court or against whom proceedings are instituted may of a right be defended by a pleader of his or her choice. In Husainara Khatun versus Home Secretary, State of Bihar 1980, the Honorable Supreme Court, after adverting to Article 39 Clause A of Constitution and after approving a reference to creative interpretation of Article 21 of the Constitution as propounded in Menka Gandhi versus Union of India 1978, held that the right to free legal services is therefore clearly an essential ingredient of reasonable, fair and just procedure for a person accused of an offence and is must to be held implicit by reading Article 21 of the Constitution. Similarly, Section 41D of the Criminal Procedure Code 1973 provides that the right of arrested person to meet an advocate of his or her choice during an interrogation also falls within the principles as enshrined within the constitutional principles and the procedural law principles. These are essential and need to be read along with the right enshrined within the Constitution. Another important right, along with other rights we have discussed, is person arrested has to be taken before the magistrate. This is specifically mentioned in our Constitution provision of Article 22 Clause 2, which provides that an arrested person must be taken to the magistrate within 24 hours of the arrest. Not fulfilling this particular requirement would definitely bring certain kind of repercussions to the state. This is a duty which has to be followed strictly, as this becomes a very important right under Part 3 of our Constitution, which is enforceable within the Constitution of our country. Person arrested also not to be detained for more than 24 hours. This is what has been specifically mentioned in number of cases from Supreme Court. Article 22, Clause 2 of the Constitution provides that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours or such arrest excluding the time necessary for journey for the place of the arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. Further, Section 56 of Criminal Procedure Code explains that a police officer making an arrest without warrant shall without unnecessary delay and subject to provisions herein contained as to bail, take or send the person arrested before a magistrate having jurisdiction in the case or before the officer in charge of a police station. Another important provision with respect to women is Section 46, Clause 4 of the Code of Civil Procedure 1973. It states that only in exceptional circumstances no woman shall be arrested after sunset and before sunrise, and for any exceptional circumstances only a woman police officer with prior permission from judicial magistrate of first class is allowed to be arrested. Information of arrested person must be provided to the nominated person. This particular right is inherent from Article 21 and 22 of our Constitution. Article 21 talks about right to life, which has been extended with its interpretation by the Supreme Court in various judgments. This says that the information of arrested person must be extended to a nominated person. The rule emerged from decisions such as Joginder Singh versus State of Uttar Pradesh 1994 and D.K. Basu versus State of West Bengal 1997. This has also been available under Section 50 Clause A of the Code 1973. The subsection of 50 Clause A of 1973 Code provides every police officer or other person making any arrest under this code shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his friends, relatives, or such other person as may be disclosed or nominated by arrested person for the purpose of giving such information. This clearly explains that the legislative intent from the Constitution has been incorporated under Section 50 Clause A of the Code 1973. The subsection 2 of Section 50 Clause A of Criminal Procedure Code 1973 also provides that the police officer shall inform the arrested person for the purpose of giving such information of his right under subsection 1 as soon as he is brought to police station. This is an important provision which is available under the Code of 1973. Further, the subsection 3 of the same section of Code 1973 provides that an entry of the fact as to who has been informed for the arrest of such person shall be kept in the books in the police station in such form as may be prescribed in this behalf by the respective state governments. Further, subsection 4 of the Section 50A of Criminal Procedure Code 1973 provides that it shall be the duty of magistrate before whom such arrested person has been provided to satisfy himself that the requirements of subsection clause 2 and subsection clause 3 has been compiled in respect to such an arrest. This is an important provisions if we have to read this particular provisions with the other provisions which says that within 24 hours it is the duty of state officials to provide that arrested person before a magistrate. Now, the right to be released on bail in bailable offence under Section 50 Clause 2 of Criminal Procedure Code provides that where a police officer arrests without warrant any person other than the person accused of a non-bailable offence, he shall or she shall must be informed the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his or her behalf. Right to receive the copy of receipt from search power to search under Section 51 of Criminal Procedure Code 1973 is available only if the arrested person is released on bail. After search, all the articles other than necessary wearing apparel from upon the arrested person are to be seized, and it has been made obligatory to give to the arrested person a receipt showing the articles taken in possession of the police. This would ensure that the articles seized are properly accounted for, and in case the arrested person is a woman, the search can be made only by a female with strict regard to decency. Another important right which has been available to an accused person is right of medical examination of the arrested person. Section 54 of Criminal Procedure Code of 1973 gives the accused the right to have himself medically examined to enable him to defend and protect himself properly. It is considered desirable and necessary that a person who is arrested should be given an opportunity to have his body examined by a medical officer who he or she is produced before a magistrate or at any time when he is under the custody. With a view, this particular provision is with a view to enable and establish for the accused person that the offense with which he or she is being charged was not committed by him, or that he or she was subjected to certain physical injury by the institutions of state. There are constantly number of instances running across our newspapers which suggest that state machineries do use physical force to avail certain kind of evidences. This particular provision, therefore, gives a right to the person that he shall not be subjected to any physical injury by the machineries of states. Whereas Section 53A of the Code 1973 deals with examination of purpose accused of rape by a particular respective medical practitioner. The state is under an obligation under Section 55 Clause A to take reasonable care of health and safety of the accused person. Further, Section 300 of the Criminal Procedure Code 1973 states that when a person has been acquitted of any offense by a competent court, any subsequent trial for the same offense would certainly put him in jeopardy, and in any case would cause him unjust harassment. Therefore, there is a right to receive free legal aid from the state. This particular right emerged from the wider interpretation of Article 21 and a specific provision covered under 39A of the Indian Constitution. This particular right speaks for right to counsel would remain an empty right if the accused, due to his poverty or indigent condition, has no means to engage a counsel for his defense. The state, therefore, is under a constitutional mandate which is explicitly covered under Article 21 and Article 39A of the Constitution, which remains a directive principle, to provide free legal aid to an indigent accused person. This is an interesting provision covered under our Constitution, provided also in our legislative frameworks, that both Part 3 and Part 4 of the Constitution discusses about this right of extending free aid to the accused person. Recently, there has been a report by CHRI which discusses about how legal aid has been extended to the accused person and brought a case for bringing more money from state so that this right does not merely exist in the constitutional or legislative provisions. Legal aid beyond constitution is also covered in Section 304 Clause 1, which provides that wherein trial before the court of session the accused is not represented properly by a pleader, and where it appears to the court that the accused has not sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expense of state. In Sukhdas versus Union Territory of Arunachal Pradesh, 1986, court held that any failure to inform the accused of this right and non-compliance of this requirement would definitely vitiate the trial. Further, in Khatri versus State of Bihar, 1981, the apex court had held that state is under a constitutional mandate to provide free legal aid to the indigent accused person, and that their constitutional obligation to provide legal aid does not arise only when the trial commences, but also when the accused is for the first time produced before the magistrate. This is also when he is being remanded from time to time. One basic requirement of fair trial is in criminal cases is to give precise information to the accused as to the accusation against him. In a criminal trial, charges during the form of foundation are must be extended or informed to an accused person. Section 218 of Criminal Procedure Code of 1973 gives the basic rule that for every distinct offense there shall be a separate charge. Another important right is right to be tried in presence of the accused. The personal presence of the accused throughout his trial would enable him to understand properly the prosecution case as it is unfolded before the court. A criminal trial in the absence of accused is unthinkable. A trial and a decision behind the neck of an accused is not contemplated by the Code of 1973 and by the Constitution provisions also. Though there is no specific provision to this effect which has been available to this time, but with the extensive interpretation of Article 21, this can be availed as a right which must be available or which must be extended to an accused person. The requirement of presence of an accused during his trial can be implied from the provisions which also allow the court to dispense with personal attendance of the accused person. Section 273 of the Criminal Procedure Code 1973 requires that evidence is to be taken in the presence of accused person. However, the section allows that the same has to be taken in the presence of accused pleader if the personal attendance of the accused person is dispensed with. Besides, fair trial requires that particulars of the offense have to be explained to an accused person and that the trial is to be taken at a place where within his presence. Another important right of an accused is that he must be understanding the proceedings. An accused person, though not of an unsound mind, may be deaf and dumb, may be a foreigner not knowing the language of the country, and there is no interpreter who is been available. And if such accused is unable to understand or cannot be made to understand the proceedings, there is real difficulty in giving effect to Section 273 of the Criminal Procedure Code 1973. Section 318 of Criminal Procedure Code 1973 provides for a procedure where accused does not understand the proceedings. Another right is right to get copies of police report and other documents. Where the proceedings is instituted on a police report or where a police officer investigating a case finds it convenient to do so, he may furnish to an accused copies of all or any of the document referred to in Section 173, Clause 5 of the Criminal Procedure Code 1973. According to Section 207 of Criminal Procedure Code, the magistrate is under an imperative duty to furnish to the accused free of cost copies of statements made to the police or any other document which needs to be relied upon by the prosecution. Further, where the proceeding is instituted otherwise than on the police report, in such cases where the cognizance of the police has been taken otherwise than as a police report, the case is not ordinarily being investigated by a police and naturally there are no statements recorded by the police. Section 207 and 208 of Criminal Procedure Code deals with supply of an accused a copy of police report and other documents and supply of copies of statements and documents to accused in other cases triable by court of session. Now, the right to cross-examine prosecution witness and to produce defense evidence. Evidence has to be given by a witnesses may become more reliable if given on oath and tested by cross-examination. A criminal trial which denies the accused person the right to cross-examine prosecution witness is based on a weak foundation and cannot be considered as a fair trial. In Muhammad Hussain versus State of Delhi in 2012, it was held that the right to have counsel at the cost of state where accused is unable to engage a counsel in part of fair trial must be extended to him. Further, in Muhammad Sukur Ali versus State of Assam, AIR 2011, it was held that a criminal case should not be decided against an accused in the absence of a particular counsel. Further, it's a court's power and duty to examine the accused person with a view to give an opportunity to the accused person to explain the circumstances appearing in evidence against him. Section 313 of Criminal Procedure Code 1973 provides for an examination of an accused by the court. It requires that the court to question the accused person properly and fairly. It must brought home to the accused in clear words that the exact case which has been raised against him. The accused will have to meet and thereby an opportunity to give is been extended to him so that he can explain all the points which has been extended to him. Accused person can also become a competent witness. According to provisions of Section 315 of Criminal Procedure Code 1973, the accused can be a competent witness for defense and can give evidence in disproof of charges made against him or against his co-accused. He may give evidence on oath in disproof of the charges made against him or any person charged together with him at the same time, but he shall not be called as a witness except on his own request in writing, and his failure to give evidence shall not be made the subject of any comment by any of the parties of the court or give rise to any presumption against himself or any person charged together with him at the same trial. Now which we'll be discussing about right to a speedy trial. Section 437 Clause 6 of Criminal Procedure Code 1973 provides that if the accused is in detention and the trial is not completed within 60 days from the first date fixed for hearing, he shall be released on bail. Section 309 of the Code gives direction to the court with a view to have speedy trial and have quick disposals. In Husaina Khatun versus State of Bihar, 1995, the Supreme Court considered the problem in all its seriousness and declared that speedy trial is an essential ingredient of reasonable, fair and just procedure as guaranteed under Article 21. And that is the constitutional obligation of the state to devise such a procedure as would ensure speedy trial to an accused person. Section 358 of the Code 1973 empowers the court to order a person to pay compensation to another person for causing a police officer to arrest such other person wrongfully. For applying Section 358, some direct and proximate nexus between the complainant and the arrest is required. The above said rights are not the exhaustive right of accused or arrested person. Other rules have also been made in consideration of interest to them. Some of them have been created by the judiciary and later on incorporated in concerned laws. Even Malimat Committee in 2003 on the rights of the accused opined that the right of an accused include the obligation on part of the state to follow the due processes of law, a quick and impartial trial, restraint from torture and forced testimony, access to legal aid, etc. The committee, after discussing these points in detail, suggested that the right of an accused recognized by the Supreme Court should be subject to the clarification and the manner of their protection and should be made statutory, while incorporating the same in the schedule of Criminal Procedure Code 1973. Another important right under the criminal prosecution is a right of bail. There is a famous dictum of Justice V.R. Krishna Iyer who says, bail, not jail. The Supreme Court in Nandini Satpathy versus P.L. Dani, 1978, at para 15 stated that to strike the balance between the need of law enforcement on the one hand and the protection of citizens from oppression and injustice on the other, the law enforcement machinery is a perennial problem of statecraft. In Rajesh Talwar versus CBI 2013, the Supreme Court observed that Article 12 of Universal Declaration of Human Rights for the right of fair trial is what is enshrined under and can be incorporated under Article 21 of our Constitution. Another important right is right against inhuman treatment. The accused and convict in criminal system of a country have the right to live with dignity. In Kishore Singh versus State of Rajasthan 1981, the Supreme Court held that the use of third degree method by police is violative of Article 21 and directed that the government must take necessary steps to educate the police so as to inculcate a respect for another fellow human. The court also held that the punishment of solitary confinement for a long period from 8 to 11 months and for putting that particular person behind bars for several days on flimsy ground must be regarded as a barbarous and against human dignity and hence violative of Article 21 read with Article 19 and 14 of the Constitution. In the words of Justice Krishna Iyer, human dignity is a clear value of our Constitution, not to be bartered away for mere apprehension entertained by a jail officer. Similarly, torture and ill treatment on women suspects in police lockups have been held to be violative of Article 21 of the Constitution. Now, we are going to discuss certain conclusions and suggestions that has been emerged from this particular course. The first one is to be informed promptly and in detail of the nature of cause and content of charge, the language which the accused must understand or speaks has to be provided. Further, adequate time and facilities for preparation of defense has to be communicated freely with the counsel of the accused, which he has chosen on his confidence. There must not be any undue delay. Thereupon, to examine or have examined the witness against him or her have to be obtained the attendance and examination of witnesses on his or her behalf under the same condition as witness against him or her. Further, the accused shall also be entitled to raise defense and to present other evidences admissible under this statute of 1973. To have free of cost the assistance of a competent interpreter and such translations need to be necessarily met with the requirements of fairness. If any of the proceeding or document presented to the court are not in the language which the accused fully does not understand or speaks, therefore, possible proceedings must be explained before or through his competent lawyer. It needs to be noted that no compulsion or testimony of an accused guilty must be made before, and because of that particular silence, he must not be determined as a guilty or innocence. Further, the last point which we are going to discuss is to make an unsworn oral or written statement in his or her defense. There has to be a reversal of burden of proof or onus of rebuttal. To provide as far as possible assistance of a woman lawyer is a need of an hour, especially concerning women accused. Thank you.